Welcome, everyone. This is class number 8 of the July 2024 Ibis Prep Florida Bar Complete Interactive Crash Course. We just had the most amazing introduction with Priscilla. She passed the Florida bar exam and the MBE in July and is now one of our esteemed instructors. And she gave a lot of great feedback. The thing that really resonated with me was her approach to essays. And what she said, I think, is the bulletproof strategy. They asked her, how many essays did you write? And she said, well, I went through all the essays from at least 2010. And if I didn't write them, I at least fleshed them out. I modeled them, I outlined them, I made sure that I absorbed 1, 2, 3. All right, let's look at some stuff. I might have Jesse add some of these things to the course. You know, I'm always finding that some of my favorite materials need to be added, and we'll add them expeditiously. But I kind of want to look at this workshop essay that I did maybe 1 year ago when Priscilla was taking the bar. So let's refresh ourselves with the important things to consider when we're writing a Florida federal con law essay. And remember, there's 3 lenses to consider. There's the federal lens, there's the Florida lens, and then there is the con-crim lens, which is Fourth Amendment, 5th Amendment, 6th Amendment. We're talking about exclusionary rule, fruit of the poisonous tree, warrant, exceptions to warrant. That's going to be a con-crim. Priscilla just put her Google Doc in the chat. And just because I have ADD, I just clicked it. But it also says we need access. So maybe, Priscilla, you can make access available to anyone who opens it. But anyway, let's not get sidetracked, Andrew. So let's talk about the Constitution. There's the Florida lens, the federal lens, and the con-crim lens, 4th, 5th, and 6th Amendment. Warrants, probable cause, exclusionary rule, fruit of the poisonous tree, Miranda rights, that whole conversation. They've been testing that a lot recently. In fact, Priscilla, I believe they tested it your year. I think they just tested it last time. It seems to be one of the more common things that they're testing. And if anyone's ever taken the UBE or California or probably Georgia, as Romel did, they test that a lot too. So I think if you went to law school, if you ever watched TV, you should be pretty at least confident that you could learn 4th, 5th, and 6th Amendment and be able to write the essay about Tommy getting pulled over with the junk in his trunk and XYZ. So we'll talk about that, but I think of the 3 lenses, that's the easiest lens, let's say, but not easy. Let's start with the Florida lens, and let's start with the Sunshine Law. It's very fitting because the sun has been booming lately, really shining a light on us. And Priscilla agrees, it's been a hot topic to test 4th, 5th, 6th Amendment, Tommy with the junk in the trunk. Okay, so let's talk about the Florida lens. First, the Sunshine Law. All meetings and records must be made open to the public between government officials. Florida Sunshine Law provides a right of access to governmental proceedings of public boards or commissions, for example, meetings. Every person has the right to inspect or copy any public record made or received in connection with the official business of any public body, office, or employees. And this is correct, instead of what the model answer wrote and forced me to read the other day. There's an exception for informal meetings between 2 people, not including the governor. So if the governor's there, it actually does implicate the Sunshine Law. Remember, I said that a logical yet failing counter argument to the Sunshine Law is what? Does anyone remember?
Privacy.
Yeah, exactly. Is the heightened right to privacy in Florida. Just a good little, piece to mention. Did anyone have any questions about the Sunshine Law? Priscilla, are you still with us?
Yes, I'm here.
Yes, I love having a co-host. Any thoughts about the Sunshine Law? Any things you remember from your studies?
Sunshine Law. I don't think it came up on my test day, but definitely it was something I saw in a lot of essays as a little subtopic to bring up. It went in a lot with access to public records, right? When they have the right to inspect or copy a public record. and just making sure that I remember when I was studying is making sure that you know that it's public meeting. So the whole point is that there's notice and everyone is able to go ahead and have knowledge of what's going on, but tying in public records as well.
Yeah, and they can be cheeky about it. It'll be like, la la la, then two legislators are at the bar and they just meet, and okay, that's not a sunshine
Mhm.
law implicator because it was an unplanned meeting. But then they say, hey, let's go in the back room and talk about the newest law. That all of a sudden becomes planned, and it gives you an opportunity to have a discussion. I've graded, everyone who timely submitted their essay for week 1, and I think the biggest feedback that I have is I'd like to see a little bit more discussion. I'd like to see what the one side will argue, what the other side will argue, and what the conclusion may be. So like maybe they'll argue as a planned meeting, so it implicates the sunshine law, but the legislators will say it was unplanned. However, on balance, the moment they decide to go into the back room and have the conversation, it became a planned meeting, and therefore the public should have had a right to access. It could also be a situation where there's a law that says like, these meetings will be held in the private and there will be no records. And you could be like, this law on its face violates the sunshine law. So it doesn't necessarily have to just be like a scene. It could be an ordinance or an act that implicitly implicates and violates the sunshine law. All right, the good old homestead exemption. Article 10, Section 4 of the Florida Constitution exempts homestead property from levy and execution by judgment creditors. In other words, a creditor cannot force the sale of one's homestead to satisfy judgment. Generally, there is no monetary cap associated with the exemption, but it's limited to half an acre inside of a municipality and 160 contiguous acres outside of municipality. Thank you, Maria, for making me smarter. Now I know the difference between contiguous and continuous. So these are the conditions of the homestead exemption. And for those of you who weren't here on Monday, she said, so this is Maria if it's wrong, but continuous refers to like time and contiguous refers to like physical property. That's what we're gonna rock with. Anyway, these are the conditions. The home is a primary residence. The homeowner is a permanent Florida resident. The homeowner owns the relevant property. Under Florida's Constitution, Article 10, Section 4, an individual's homestead is exempt from liens imposed by most creditors. However, the Constitution permits a narrow class of creditors to bypass homestead protection and successfully levy onto homestead property. These creditors include tax and assessment lienors, so Uncle Sam, mortgagees, so people, usually banks that have an interest in your property, whom the homeowner contracted with to finance the purchase of their home, and mechanics liens or construction liens, laborers who perform work on the property. It would actually also include like construction liens and home owners association fees and mechanics lien, just to add. Okay, if the home is owned by a husband, this is a question from the audience for the record. If the home is owned by husband, but wife lives there as well, but isn't on the deed, does the homestead exemption extend to her since they're married? Yes, right? You're not gonna be able to strip her of her primary residence. That's like one of the main protections, and it's probably assumed, I mean, I just need to see the fact pattern, but because they're married, they have some sort of tenancy by the entirety. But regardless, that would be her homestead. The homestead protects you, your spouse, and your children. So it would be her homestead. Let me give you all a little story. I'm in this thing called a business networking group, BNI, and I do it, fortunately for me, 7 o'clock in the morning on Wednesdays. So it's been a long day. I also tutored 6 of y'all throughout this day. So just imagine. But the educational moment, they said the power of storytelling. You should always be telling a story. Everything's about a story. So I'm like, all right, let me start telling some stories. So here's a story of O.J. Simpson. He was drafted by the Buffalo. No, that's not the story I'm going to tell. And I'm going to tell the story of his more famous act, right? When he, let's just fucking call it what it is. When he killed his wife, and he was not convicted criminally because it wasn't beyond the preponderance of the shadow of a doubt, right? It wasn't, there was reasonable doubt that he didn't do it. The glove didn't fit. However, he was found liable for wrongful death. He was found liable in civil court for some things. So how did he plan on not losing any money? One thing that he did was he went out to the middle of Florida to, non-municipal Florida and bought a huge property. Let's say it was 159 contiguous acres, right? So that when he lost the civil battle against the family, they tried to take money from him, but he's like, I don't have any money. All I have is this huge mansion that's my homestead, and you can't take it, right? So that's kind of one real life example of how probably you shouldn't use the homestead exemption. I don't think anyone should go out and plan to do things like this, but that's kind of one example of what it means, a judgment creditor. Like there was a judgment, a civil judgment found against him, but they couldn't take his homestead because it was his homestead. That's kind of the protection you get. I also heard, and this is all alleged, everything I'm saying is just stories, so don't fucking take it as two per word. I don't have any true proof of this, but also he bought a huge life insurance policy on himself before that, like a cash value life insurance policy that also was untouchable. So it makes him look pretty guilty under the facts. There's a lot of other things that make him look pretty guilty. And now that he can't defend himself, I guess I shouldn't say anything more, but let's just understand the homestead exemption. It protects your property from levy, which means, attachment or foreclosure or whatever it may be, by judgment creditors. That's the main point of the homestead exemption. It also allows, there's another homestead exemption that allows for a tax deduction from your property. I think it's two separate deductions, $25,000 each, that amount to $50,000 from the overall value of your home. So you can get a little tax break for your homestead, but that's the main component of the homestead exemption, that it's up to half an acre inside a municipality, 160 contiguous acres outside a municipality, and the creditors who can pierce it are, taxes and government judgments, mortgagees, construction liens, homeowners association fees, mechanics liens, basically anything related to the property itself. I find that, and if this is you, just know that you're not alone. A lot of people confuse who can pierce a homestead exemption and who can pierce a spendthrift provision of a trust, right? We'll get there when we do trust, but the spendthrift provision of the trust would be like alimony or child support. That's not this, that's that. So if you're one of those persons who's confused that in the past, you're not alone. Okay, here's another piece. We kind of mentioned this. The governor, well, let me see what the chat's saying. When the home is sold, can the judgment creditor go after the proceeds of sale of the estate? Erica, that is a phenomenal question. I'm one of those people who believes there are such things as dumb questions. I'll be the first person to just ignore a question. That's a phenomenal question, because the answer to that is, well, it depends who the creditor is. I mean, if it's Uncle Sam, he's gonna get it. But if it's a typical creditor, the answer is potentially no. If the proceeds can be shown were intended to be used to buy another home, then they are indeed protected. So if you sell the home and the proceeds are put in a fund, and it can be shown that that fund, the intention was to buy another home, then those are homestead funds. You can't have two homesteads. So, look for the fact pattern where he's living here for 8 months, the place he's living 8 months is his homestead. Your homestead, there's one can it be a mobile home? Well, if it's your home and it's affixed to the ground, then sure. But yeah, these are some considerations that come up with a homestead. I think you should really go through a bunch of essays and read model answers that deal with sunshine law and homestead to make sure that you're really confident in those subjects, because I always expect one of those two to be tested, precisely because they're specific Florida topics that people from New York and California are by definition foreign to. And so it kind of helps Florida keep the passage rates low by testing about that. So if a homestead home is sold, the proceeds may still be protected so long as there are good faith intent to reinvest into another homestead within a reasonable time. That's why Priscilla gets paid the big bucks. Okay, so let's talk about a special legislative session. The governor has the authority under the Florida Constitution to call a special legislative session. Special legislative sessions must be limited in scope, and the absence of the requisite vote of the members of the House and Senate, 2/3 vote, no new matters may be addressed during a special session other than for which the special session was called. So just look for a fact pattern where, the governor calls for a special session, and this is what they're probably going to test on. New matters being addressed. The special session was to talk about a response to COVID, and now we're bringing up abortion, right? That would be not cool unless they had a 2/3 vote of both the House and the Senate separately. Cool. Enactment clause. So, well, this is more about just enacting law in Florida. There needs to be an enactment clause, be enacted in the state legislature of Florida. It doesn't need to be those exact words, but it's pretty much similar, something that's an enactment clause. Read in each house 3 times, so we'll refer to that as bicameralism, approved in each house. And then single subject, again, that's pretty heavily tested. Well, there'll be a law, a proposed law, and again, it'll be like about abortion and about wearing masks, and that would be addressing 2 things. We're gonna really keep things narrowly focused. A short title that sufficiently describes the subject matter of the law, relate to the health, welfare, morals of the people of Florida, and for sure, it cannot be vague or overbroad. Just so that I can hear the crickets out there, can anyone remind me what the definitions of vague and overbroad are? What's it mean if a law is vague?
I was gonna say that vague is when it's not specific enough to actually understand what the question or whatever is being addressed may be.
I meant to mute myself when I cracked my knuckles, but I just mentally muted myself. Yeah, it cannot be vague, like you don't know what's being punished. And then what about overbroad? What does that mean, Erica? While you're on the hot seat.
So overbroad is when it's too much of a generalization and it can kind of be a catch-all provision that too many things are gonna be swept under whatever's being asked.
Yeah, overbroad means exactly, it's too sweeping. It covers, it's punishing unintended behavior. Excellent. Special laws versus general laws of local application. Okay, it looks like someone, probably me, was not that diligent and didn't even define these. It gives us an opportunity right now. What is a special law? Does anyone know? Does anyone know what a special law is? I just write it, you guys just read it. A specific county and it requires a referendum, notice in a referendum. Just a vote. for those.
Yeah. Come here, tell me a secret of my ear.
Erica, you're just on camera. You're hearing secrets in your ear, but don't worry, it's cute.
Sorry, say hi.
Tell her no secrets. What you gotta tell everyone. No secrets.
She ran down the stairs to tell me a secret, so there we are.
Tell her that in the law there are no secrets. There's no attorney-client privilege right now. Okay, so special law applies to a specific county, requires notice in a referendum, where general law applies to the state uniformly. And then does anyone remember what a general law of local application is usually based upon? Someone put in the chat. Yeah, population, exactly. Is based on population. You know, it could be very quickly, like, the first issue is what type of law is this? In Florida, there are 3 types of law: general laws, special laws, general laws of local application. General laws apply to state uniformly, special laws applies to specific counties and require notice and referendum. General laws of local application are typically based on population. Here, this law is likely a special, you know, it doesn't have to be super long, but you just want to be methodical and touch all the points. As Priscilla was saying before we did the recording, you should anticipate most of the topics that you're going to be tested on and just kind of have a scripted dialogue that you could write about. I think that's really what this is all about. You know, I feel confident I could take any bar exam and do well in the essays because I know if I see the issue and I recognize the issue, I'm like a parrot or like one of those things where you pull the string out of their back and then they start talking. Like I know the exact words to use, and that's just what I want everyone to train themselves to be able to do, is just recognize the issues and have a prepared dialogue that you're ready to articulate. Cool. Population. All right, so home rule powers. Municipalities may enact ordinances that do not conflict with Florida federal constitution. The most precious powers a city in Florida has are its home rule powers. The ability to establish its form of government through its charter and then to enact ordinances, codes, plans, and resolutions without prior state approval is a tremendous authority. That's a nice little piece about the home rule powers. This goes hand in hand with chartered counties. Chartered counties have municipalities with home rule powers. So Dade County is a chartered county. Miami is a municipality with home rule powers. So non-chartered counties are not self-governed. They cannot enact ordinances. They just have to follow the general laws of the state. Whereas chartered counties can have their own governance. They can have municipalities and things of that nature. One thing that's important to note is counties, not the state, can collect, or let's say counties / local governments, not the state, can collect taxes. Ad valorem taxes specifically. Does anyone know what ad valorem taxes are? Property taxes. Those are not collected by the state. They're collected by the local municipalities. I actually, yeah. Property taxes. They're not fun. I was at the gym today. Some point in my day, I went to the gym and these people were talking about property taxes and allegedly, like in Miami, if you have property from before a certain date, you're like grandfathered into some property thing. I don't know if I believe them or not, but I was definitely eavesdropping on it. Caught my attention. Okay, vague. So we already defined this. What's being punished? It lacks specificity. I think every con law essay, you should argue that the law is potentially vague or overbroad. It's just a very easy thing to argue. And then overbroad punishes more than necessary intended. It punishes legal speech. So consider loitering. Is it vague because what does loitering mean? Hanging out or being annoying? Laws must have specificity. The Kluger Doctrine, access to courts must be restricted for overpowering public necessity purposes, and there must be an alternative. So I mentioned the Kluger Doctrine last class. In Florida, you have a fundamental right to access courts, but that right can be abridged for public necessities under the Kluger Doctrine. And then general obligation bonds versus revenue bonds. GO bonds, GO bonds, general obligation bonds are used to build schools or used to build parks. They're collecting money to build something for the public good, and we're going to pay back the people who pay the money over time plus interest via taxes, right? So it requires a vote because they're paid back via taxes. So via taxes. And then revenue bonds, they require feasibility studies and are paid back via revenue. So we could think of like a school or a park as a geo bond, and we could think of like an airport or a toll bridge as a rev bond. So just to remind everyone, you know, there's so many ways to learn the law. For me, I really believe I read the best from books, and I think that, you know, I did my best to write this book for everyone that they could read from and learn from. And the con law one, I remember I wrote this last administration over winter break, like over the holidays, and I cruised through contracts and torts. And then I got the con law and I was like, oh, here we go. And it took me, I hit what they call a writer's block. I was just like, this is going to take me forever. There's just so much I have to cover. And I know if I miss one thing, I'll be stoned. So it took me a while to accept what I had to do. So once I accepted what I had to do, I did it. And here I broke down, I think I started actually with federal, so we did the opposite, but I did break down the Florida lenses and I ranked them in order of likelihood to appear in an essay. Again, that's a subjective ranking by me, but you know, there's definitely some thought to it for sure. And so I did sunshine law, which we talked about, homestead exemption, and you see, I kind of went pretty deep into these things, like extra deep. Enacting law in Florida, types of laws in Florida, home rule power, types of counties, special legislative sessions. We talked about all that. Separation of powers. Just as there must be separation of powers at the federal level, there cannot be encroachment or entanglement at the state or local level. Certain powers are vested to respective branches. Be especially on the lookout for law or ordinance that unconstitutionally grants sentencing power to a legislative or executive branch, right? That would be a judicial function. And then constitutional officers, I dug deep and teased out all the constitutional officers for you. Here's a good list of them. Constitutional officers in Florida include the governor, the lieutenant governor, the CFO, the commissioner of agriculture, state attorneys, public defenders, sheriffs, tax collectors. Erica, your daughter's loving this one. Property appraisers, supervisors of elections, clerks of the circuit court, county commissioners, district school board members, and superintendents of schools. See, your daughter probably knows at least one constitutional officer. These officers have vested duties and must complete relevant ethics courses. So just, it's something that was tested actually my year, February 2017. They're talking about the mayor, and the model answer did talk about the vested duties of the constitutional officers. So it's just like could be mentioned. Kluger Doctrine we talked about. Amendments to the Florida Constitution. Proposed amendments to the Florida Constitution may be made by a joint resolution of the Florida legislator, a citizen's initiative, a proposal from the Constitution Revision Commission, or a proposal from the Taxation and Budget Reform Commission. A proposed amendment requires at least 60% approval from voters to pass. So that's amendments to the Constitution. Defamation is not protected by the First Amendment. Florida does have an express right to privacy. The Florida Constitution states that, right, it's an express right to privacy. So it can be interpreted that Florida's protection of privacy is even greater than that afforded by the U.S. Constitution. It's important to note and discuss in the essay that the right to privacy will not overcome a sunshine law argument, but still note it. But like I said, I've kind of fleshed that out for everyone. And then right to work. In Florida, the right to work is an enumerated right in the Florida Constitution. These rights are looked upon as fundamental rights. In Florida, one may not be granted or denied work based on their membership or non-membership to a union. And then here I talk about the municipal bond thing again. Excessive bail. The purpose of a bail determination in criminal proceedings is to ensure the appearance of the criminal defendant at subsequent proceedings and to protect the community against unreasonable danger from the criminal defendant. Under the 8th Amendment of the U.S. Constitution and similarly adopted by the Florida Constitution, bail is excessive when set at a figure higher than any amount reasonably calculated to ensure the asserted government interests. Taxation considerations, I said municipalities are the ones who collect taxes. When deciding if the municipality is exempt from ad valorem taxes, you must look to the government purpose versus commercial purpose test. If the land is being used for a private purpose, it is not exempt from ad valorem taxes. On the other hand, if the property is being used for a government purpose, it will be exempted from paying these taxes. It's important to note that ad valorem taxes are levied by counties and municipalities, not the state. Rights of convicted felons. So a person who has been convicted of a felony is not eligible in Florida unless they've had the right to vote restored. Pocket vetoes, I talked about this the other day, that unlike the president, we do not allow a pocket veto in Florida. So if the governor fails to sign a bill that's passed both chambers, it still becomes a law. During a legislative session, the governor must sign or veto legislation within 7 days of transmittal, or it becomes law without his or her signature. Post-session, if the legislative session adjourns, sine die or sine die with no appointment date for resumption, or for more than 30 days during the original 7-day deadline, then the governor must sign or veto legislation within 15 days of transmittal, or it becomes law without being signed. Again, that's deep in the weeds of these, but I probably took this right from a model answer to just, show you all. The purpose of this book is I went into the weeds. I've tried to leave absolutely no stone unturned and know that these things can be tested. But if you're, thinking how important is it, it does go in order, in my opinion, of like what's most likely to be tested. So, they could test pocket vetoes, advisory opinions. Florida Supreme Court can issue advisory opinions. The U.S. Supreme Court cannot. When we talk about advisory opinions, that means giving an opinion without an actual case. Like in the Supreme Court, that's why it'll always be like Roe v. Wade or Tommy v. Johnny. There has to be a case, where in Florida they can issue rarely advisory opinions. Judicial procedure, right? Just kind of how a law becomes a bill. Prohibited subject matters. How a bill becomes a law. Prohibited subject matters. Some things are prohibited. Taxation, elections, petite juries, conditions precedent to bringing civil or criminal claims, venue rules and rules of evidence. These subject matters are preempted by Florida state law. So Special laws and general laws of local application cannot cover those matters. Those are expressly limited to the state of Florida, like taxation and venue rules and conditions present to bring suit. And then finally, things that are under the original jurisdiction of the Supreme Court. Bond validation proceedings, imposition of the death penalty, invalidation of a constitutional provision. Those are some examples. So, you know, I'm telling you, this took me a long time to write, and I did all the crimes too, because I really wanted to leave no stone unturned, but I know this is an extremely long letter, and I hope you could crush the Florida Bar Con Law essay. But I just wanted to show, you know, there's a lot of places to learn, and the book really leaves no stone unturned. But if we go back to this worksheet I was working on, you know, this is kind of like the main pieces. Now, again, in my book, I do federal lens first. In the essay worksheet here, I do I do Florida first. And there's no real rhyme or reason to that. You could get an essay that's all Florida, or you could get an essay that's all federal, or you could get most likely a mix of both. So it's like, don't think that one lens is more prevailing than the other. They're just two different lenses, and you know, we're looking through them both. So now that we've looked through Florida, let's take a look at the federal lens. I think it's very important to start with state action, justiciability, and standing, right? These three things. Pretty much every essay can kind of start off with that when it's a con law essay, because it's just a conversation of like, you know, individual rights. Is it ripe, meaning it's not too early? Is it not moot, meaning it's not too late? Does the person have standing, injury, causation, redressability? And is there state action that sufficiently implicates constitutional considerations? You should just kind of get in the habit of talking about those things right off the bat to just kind of get your points. It's like, you know, the body of law in contracts, UCC versus common law. It's like the beginning in the torts essays when we say Florida is a modified comparative fault state and abolished joint and several liability. When it comes to a con law essay, it just feels nice to say we need to see if there's standing, justiciability, and state action. Okay, so First Amendment. Now, again, if I were to read in my book, and I'm not going to do that because it would take literally all night. This is the exact point in time where I hit my wall. It was right here: traditional public forum, designated public forum, limited public forum, and non-public forum. I had to do so much research to write this 18-line, you know, part of the book, because it's very complex, convoluted, and there's a lot of potentially conflicting thoughts in the world of literature. It took me a long time to kind of boil that down for everyone, but it's not the most important thing. I just wanted to make sure that I touched everything. But you could talk, you know, you could see the freedom of speech really does start off with just like the main ideas. Freedom of speech is part of the First Amendment. There's also freedom of press, freedom of religion. We should definitely add, anyone know what the other freedoms are from the First Amendment? Speech, press, religion, association, petition, and assembly. I heard to add that. It includes like fundamental rights, freedom to travel, which will be subject to strict scrutiny. Freedom of speech is going to implicate content-based versus content-neutral discussion. So if it's content neutral, it will be time, place, and manner restrictions. Time, place, and manner restrictions are subject to a heightened form of intermediate scrutiny, where there needs to be alternative opportunities to have that communication. But even in a public forum, the government may impose reasonable restrictions on time, place, and manner, so-called time, place, and manner restrictions, provided these restrictions are justified without reference to the content of regulated speech. And here's the intermediate scrutiny, heightened intermediate scrutiny, that they're narrowly tailored to serve a significant government interest. Do you see how that's the heightened intermediate scrutiny? I'm meditating on this for a second because I think that that's hard for people to grasp. Strict scrutiny is, you know, compelling interest, narrowly tailored, no alternative means. Intermediate scrutiny is substantially related to an important government interest. This one is narrowly tailored to a substantial or or important government interest, but it doesn't say compelling. That's why it's kind of like in between intermediate and strict. It's heightened intermediate scrutiny that applies for a time, place, and manner, content-based analysis. So it also has to leave ample alternative channels of communication. So the lemon test, again, I don't think they're likely going to test that because it's been abrogated since 2023. And then what types of speech may be regulated? Speech that's likely to incite imminent loss activity, obscenity, which appeals to the prurient interest of human nature and doesn't have any artistic or literary value, fraudulent or misleading commercial speech. I think hate speech would be included nowadays, and something else, right? Maybe that's good for now. Okay, so that's the First Amendment. When you get a federal con law essay, the main things that they test are First Amendment, fundamental rights, Fifth Amendment, due process rights, and 14th Amendment, equal protection rights. And included in that would be the scrutiny levels, the suspect classes, and, you know, freedom of speech, freedom of religion, substantive due process, procedural due process, and then, you know, suspect classes, quasi-suspect classes, things like that. So here we have the levels of scrutiny. Levels of scrutiny under the three-tiered approach to equal protection analysis. So equal protection stems from the 14th Amendment. Strict scrutiny, the government must show that the challenge classification serves a compelling state interest and the classification is necessary to serve that interest. So the suspect classes are race, alienage, national origin, and religion, either under equal protection or establishment clause analysis. And then in Florida, disability is also recognized as strict scrutiny. Classifications burdening fundamental rights. So denial or dilution of the vote, interstate migration, you know, ability to travel, right to vote, right to travel, access to courts, other rights recognized as fundamental. We typically think of the camper mnemonic, contraception, traditionally abortion, but now that's been abrogated, marriage, procreation, right to educate your children, and the right to raise your family. Right to work, we said, is a fundamental right in Florida, right to privacy, right to unionize, kind of tied up in right to work, access to courts, anything under the, you know, Second Amendment. Is it a right to public education or private education? It's not really either. It's a right to choose how to educate your children. They can't force your kid to go to public school. You could homeschool your kid. You could take them to private school. It's just the right to like be the, I don't want to say commander, but be the decision maker of your child's education. So let's see, quasi-suspect classes, gender illegitimacy, and then rational basis would just be everything else: age, wealth, height, weight, eye color. Minimum scrutiny applies to all classifications other than those listed above, although some Supreme Court cases suggest a slightly closer strict scrutiny. A second order rational basis test involving some weighing the state's interest may be applied in cases, for example, involving that disadvantaged mentally I'm not sure, homosexuals or innocent children of illegal aliens. This is known as rational basis with bite, just so you know that concept. Okay. I didn't make this colorful document. I think one of my tutors did. All right, so due process is going to be procedural due process, like notice and hearing, and then substantive due process, like discrimination. I was explaining to someone today the difference between substantive due process and equal protection. Equal protection is if you're discriminating against a certain class of people, like women or an age group, right? That's equal protection. I gave the example of potentially during the pandemic, requiring all people to wear a mask could invoke substantive due process, all people, requiring just men to get a vaccine could invoke equal protection. You're targeting the men, right? So that would be the difference between equal protection and substitute process. Equal protection under the 14th Amendment, substitute process is when a law discriminates against everybody. Equal protection is when a law discriminates against a certain class of people, and there's scrutiny tests. We talk about the privilege and immunities clause under Article 4. You can't discriminate against out-of-staters. The privilege and immunities clause of Article 4, Section 2 of the Constitution states that the citizens of each state shall be entitled to all privileges and immunities of the citizens of the several states. So after this, I mean, they don't test too much on Florida essays because it's not always federal. It's usually a Florida law, but like, it's just things to note. So I'll kind of go over these, you know, quicker. This one comes up more often than others, takings, but I talk about in real property too. But this is just compensation, the eminent domain conversation. So pursuant to its powers of eminent domain, the state and local government may take, appropriate, or physically invade private property for justifiable public purpose with just compensation due and owing to the owner of that property. Eminent domain also covers the taking of personal property. A regulatory taking is when there's a law that renders property economically useless. So regulatory taking, the Penn Central multi-factor balancing test, when the ordinance, like no corn is allowed to be grown and you're a farmer who grows corn, renders your land economically unviable and you've lost the investment back expectations of the property, that's a regulatory taking. A physical taking is when they're like, hey, Lady in Hialeah, we're taking your property to expand the soccer stadium. That's a physical taking. Right to privacy, the Florida Constitution explicitly guarantees the right to privacy. And so the right to privacy in the state has been taken more serious, even than taken under the federal Constitution, where it's only implicit. The commandeering clause, we talked about this in my federal class yesterday. It's like the federal government cannot compel states to enact legislation, but they can induce them through conditional funding. Like, we're not going to give you money for your roads unless you raise the drinking age. And then encroachment. I really want to meditate on encroachment. Well, let me talk about these two real quick. Commerce clause and dormant commerce clause. Again, these are more federal issues. Just know that Congress can regulate the channels, instrumentalities, and economic activities through the commerce clause. And the dormant commerce clause would prevent Florida from enacting any legislation that would, on its face, burden interstate commerce or unduly burden interstate commerce. Now, this one comes up a lot, encroachment. Encroachment comes up a lot and it's hard to see. I just recall this from grading essays. You know, when I grade your essays, it gets kind of formulaic for me where I'm looking at, you know, Frick and Fran, your essays look very similar to each other. You all wrote about the obvious things and you all missed the hard things, right? Like for the last essay, I think the professor versus university contracts one, like I was literally writing modification, accord and satisfaction, and promissory estoppel on like everyone's, because those are like three things that everyone missed, right? Encroachment was one of those things in con law that I was writing on people's essays last year. Like, look out for encroachment, entanglement, entwinement, usurpation, some scenario where one branch of the government is stepping on the toes of another branch or doing something that they're not empowered to do. So really be on the lookout for encroachment. Those are the federal lens issues. You know, if we go through how I order them, key federal concepts, state action, standing, justiciability, I kind of talked about them. And then I said Fifth Amendment due process. So Fifth Amendment, look for due process, takings, right against self-incrimination, Miranda rights, and double jeopardy. I have seen double jeopardy tested before. I'll get to that a little bit later, actually. Equal protection, we talked about. So due process and equal protection, almost on every con law essay. They're very easy to write about. Due process, equal protection, it's like vagueness and overbreadth. They're very, very heavily tested as just like constitutional issues. First Amendment, freedom of speech, and you can read about my rabbit hole I went down here. Obscenity appeals to the prurient interest of humanity and is devoid of social artistic value. First Amendment, freedom of religion. Right, religion is a sincerely held belief, free association and free exercise. Fundamental rights, we talked about race, alienage, national origin, disability, contraception, marriage, procreation, right to educate your children, and right to raise your family. Also, right to travel, right to vote, right to work and join a union, right to privacy, right to be a candidate, right to be free from governmental takings, access to courts, due process rights, right to bear arms, right against unreasonable search and seizures, right to counsel, right against self-incrimination, right against double jeopardy, right to speedy trial, right to confront witnesses, and right to trial by jury in certain circumstances. Access to courts is tested a lot. Like it might be cheeky how they test it. Like it doesn't seem like they're restricting your access to courts, but it's like in the law, it says you don't have any way to appeal this or something. That would be something that would implicate access to courts. Definitely be keen on the scrutiny levels. Vagueness over breadth, I said, is tested a lot. The separate branches of government on all levels, including local, state, and federal, have certain powers. It's improper for any commingling, entanglement, entwinement. Federal level executive branch has veto, power to enact laws, power to exclusively represent the country in foreign affairs. I mean, these are federal issues, but just know the executive branch, the governor, carries out the laws, the legislative branch makes the laws, and the judicial branch subjects the laws to judicial scrutiny. We talked about takings, eminent domain, state sovereignty, police powers. Florida can, do things that are not preempted by the federal government. Sovereign immunity. Florida has waived sovereign immunity for tort claims involving operational decisions, but not planning decisions. So running a parade is operational, whereas directing what route it goes is a planning. That's a really tough concept, but just should be mentioned. So individuals cannot sue the state except officers in their official capacity or if the state consents. I think Safwan in my MBE class typed yesterday about, doesn't the president get sued sometimes? Well, yeah, he would be sued in his individual official capacity, not like as a representative of the USA. So we talked about these things, ex post facto laws, contract laws. Look out for that. Like a curfew violation would be a contracts clause concept. Bill of attainder, double jeopardy. These are the federal common law issues. I'm just going to take right now 8 minutes maximum to talk about the Crim Pro ideas, and then I'll pick up with it on Saturday, and then we'll look at a whole bunch of essays. And I assigned you 2 essays to write. One of them is about this Crim Pro, 4th, 5th, 6th Amendment, and the other has some common law issues. Just in general, I wanted to honestly assign you all 3 essays because I think there's 3 lenses, and I should have assigned you 3 essays, but most of you are already falling behind on your essay submissions, and I didn't want to be that guy, so I only assigned you 2, but I would listen to what Priscilla said. You should go through all the common law essays that have been been written and check them out and make sure that you are confident in all of them, because of the 2 I've assigned, they don't cover all the things you need to know. My book does, if that makes you feel better. So then just, take a few minutes to go over these last concepts. Let's see what we got here. In order, it says the con-crim law essay. So 4th Amendment, right against unreasonable search and seizures. The 4th Amendment of the U.S. Constitution, which is mirrored by the Florida Constitution, protects against unreasonable searches and seizures. Private individuals have a reasonable expectation of privacy in their persons and effects. A search occurs when a government or law enforcement agent conducts a search of property, information, or conversations, and there must be probable cause supported by a warrant or a circumstance excusing a warrant. Whether the police have a legal basis for stopping or arresting a person depends on the totality of the circumstances surrounding each stop or arrest. So, right here are the exceptions to the warrant requirement. I'll talk about this on Sunday or Saturday, but we use the space as mnemonic. Search instant to arrest, plain view doctrine, automobile exception, consent, accident circumstances, and stop and frisk. So 4th Amendment is the right to privacy. 5th Amendment is Miranda rights. The 5th Amendment right to counsel attaches when a person is placed in custody. Custody is generally defined as any situation where a reasonable suspect would not feel free to leave or where they're deprived of their freedom of action in any significant way. So interrogation is when there's, questioning that would lead to incriminating statements, and that's when they must be read their Miranda rights. So if you watch, I don't know, a lot of TV, you'll understand the Miranda rights. Just know you should be very confident in 4th and 5th Amendment unreasonable search and seizure, reasonable expectation of privacy, custody, interrogation, Miranda rights. These things could all very well be coming down the pipeline. Sixth Amendment. So the difference between Fifth and Sixth Amendment right to counsel, Fifth Amendment right to counsel is your right to counsel when you're in custody. Sixth Amendment is your right to counsel after you've been charged, after adversarial proceedings have begun. This is the big one right here, 4 and 5. Exclusionary rule. The exclusionary rule provides that evidence that the government obtained in violation of an individual's constitutional rights is barred from admission at their trial. A defendant aggrieved by an unlawful search and seizure may move to suppress anything so obtained for use as evidence. You know, it's the exclusionary rule. That it was a motion to suppress. Remember, just because something is excluded doesn't mean the case is dropped. It just means that that evidence is excluded. And then the fruit of the poisonous tree doctrine just means that anything that comes as a direct result of anything found as a violation of the exclusionary rule will also be inadmissible at trial. I really think that, like, of all the things people pretended to study in college or in law school, this is the one that they actually learned, like Fourth, Fifth, Sixth Amendment, exclusionary rule, fruit of the poisonous tree doctrine. If you're taking the MBE, this stuff is tested pretty intently too. So definitely, you know, it's worth learning. When I first started teaching for the bar, I barely taught this. I was like, they never test it. They didn't used to. Now they've been testing it very often. So, you know, got to adapt to the circumstances. So I do this a little bit more. Standard ground laws, right? In Florida, a person is justified in using or threatening to use force, except deadly force unless reasonably necessary, against another when and to the extent that person reasonably believes that such conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force. So that's, you know, Florida's pretty famous for that. We can't have impermissibly suggestive lineups. And then I said it's conceivable but rare that they test these crimes: robbery, battery, burglary, murder, and manslaughter and arson and theft and attempt and solicitation, vehicular homicide. There probably would more likely test them on multiple choice as part of criminal procedure, and they'll definitely test them as federal subjects on the MBE. In general, there's this website, Hornsby.com, I think it is. Yeah, and he does a great job of, you know, going through the Florida crimes, and like you can click, like, let's say assault and battery and look at battery, and he, you know, tells you the difference. He does a really good job on the homicide ones, like murder in the first, second, third degree. You know, he does a really good job of going through them. So that's a pretty solid link. You know, I know we went over a lot, and here I have a great folder of some materials I'm going to add to the classroom. So look out for some new classroom materials. Just know we do have a questionnaire for, you know, federal con law. We have a questionnaire for Florida con law, and we have a questionnaire for Crim Pro con law. So the questionnaires don't stop, but there are 3 distinct questionnaires, and they might need to be added to the drive. So just give us, you know, few hours. We'll add everything that needs to be in the drive to the drive. Your goal is to be able to do those 3 questionnaires and just be able to articulate them as always. And then, of course, come to the workshop on Saturday, and then, you know, over the weekend, write your 2 essays. By Monday at midnight, you're supposed to have submitted 6 essays. And then, just to give everyone foreshadow, we'll do real property next week, which is a fun essay subject. And then we'll switch gears and really start diving into Florida multiple choice, which can be a major difference maker. So as always, I'm super grateful for everyone spending the evening with me, especially Priscilla. You are amazing. I'm gonna go ahead and stop this recording.